rise.
Good morning, please be seated. Mr. Connolly, please
Morning.
stand. Would you like to take the oath or the affirmation?
Affirmation, thanks.
Thank you. Please read out aloud the card.
I, Michael Christopher Connolly, sincerely declare and affirm that the evidence that I give to this Commission shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Please take your seat and make yourself comfortable. Yes, Mr. Zapier.
Yes, if it pleases the Commissioners, I appear with Mr Malone on behalf of Mr Connolly.
Thank you. Do you have any examination in chief?
No, I don't.
No. All right, thank you. Yes, Ms Cahill.
Thank you, Commissioner. Mr Connolly, I'd like to begin by just clarifying a couple of aspects of the evidence that you gave on the last occasion. So I'm going to ask the operator to turn up day 5 of the transcript, page 306. Now, do you see the line numbering on the left-hand side of the page?
Yes?
Yep. So if we go down to 25 and just where my question appears after 25, all right, did you ever get to the view yourself whether there was an association between junket tour operators and the risk of money laundering or criminal infiltration? And you give an answer there where you talk about the view that you did come to in relation to junkets and risks. And then I say, did you come to a view that there was an association between junket tour operators and the risk of money laundering or criminal infiltration of those tours? And you answer, no, I never came to that. I said, you never had that view? You answer, obviously in more recent times, those things have been highlighted, but as a government casino inspector, we didn't have access to that sort of information. We go over the page. So in recent times, since when, I ask, and you say 2019 through the mid-year inquiries, go on to explain about probity checks on players. Can I just clarify with you that you meant to say there that you did not appreciate the association between junket tour operators and the risk of money laundering or the criminal infiltration of those tours until 2019?
I thought it was and I'm still of the view that it was somebody else's responsibility to identify that risk of money laundering. Not
talking about the identification of the risk, whether you were aware of the risk.
No.
So when...
Well, I guess at what sort of level we're talking about there, aware of the risk. Yes, I'm aware that these are high wealth individuals, but I have no information about where their money comes from. I guess I was aware that there was a risk that their money could have come from some illegitimate source. So I suppose the answer to that question is yes, I'm aware.
Two things. A risk of money laundering occurring at the casino through junket tours. Were you aware of the risk that could occur?
Yes, I think that's fair.
Any time before 2019?
Yeah, I think that's fair, yeah.
So since when?
Probably since I've started working at the casino. I mean, there is a risk of money laundering at casinos more generally, but I don't see that that's any different from junket operators as well.
All right, and the risk of criminal infiltration of junkets, separately from money laundering, just the association of criminals with junkets, were you aware of that risk at any time?
I would say that I would be that I'm aware of the risk, but I'm not aware of it actually happening. Yeah.
Right, so just staying with the risk, when did you first become aware of that risk?
I guess, you know, the value of the money that these people were spending would probably highlight some sort of risk, but
just stay focused on my question, please.
I'm trying.
When would you have become aware of that risk for the first time?
I don't know. As a government casino inspector, probably.
So that's pre-2012?
Pre-2012, yes.
Now, if we can go to page 309, this is a different topic of your evidence that I want to clarify with you. Do you see around line 10? What I'm asking you about here is the repeal of the junket regulations in 2010. Do you remember me asking you some questions about that? And I'm referring at 5 to some evidence you've given in your witness statement. We sort of cut across each other here, but you agree with me that you had no involvement or input into the decision regarding the repeal of the junket regulations, and I think because you were at fisheries at the time was the effect of that evidence. Can I just show you this document, DLG.0001.0007.002. And it's a letter of the 4th of December 2009 to you in your role as acting CCO. Have you got that in front of you?
Yes, I have.
Yeah. And this is before you went to fisheries, of course.
Yes, it was.
Yeah.
Just before?
Yep. Because it was early 2010 that you went off to fisheries.
That's correct, yep.
Yeah. And this is a letter from Mr Preston seeking approval for the removal of the requirement for approval of junket operators that's contained in the regulations at that time. The first paragraph refers to recent discussions between Mr Preston, Mr Hume, you and Mr Del Preti.
Yes.
Can you remember what those discussions were?
Not in any great detail, no.
Did you indicate in those discussions to Crown Perth representatives your support for the removal of the requirement that junket operators be approved by the GWC?
I don't recall.
Right, now I'm going to show you this document, DLG.0001.0007.002. Oh, sorry, that's the same, sorry, at 0005 we're on the same document. Page 0005. So there's some handwriting at the end of this email. Do you see the first lot of handwriting just where the operator's enlarging the redaction of the signature? Yep. Can you please prepare an agenda item for the GWC? Is that your handwriting?
Yes, it is.
Right. So did you speak to Mr Toyne about preparation of an agenda paper in respect of this letter?
I don't recall that I did. I think I spoke to Mr Del Preti about preparation. I don't recall speaking to Mr Toyne about this.
So you spoke to Mr Del Preti, and did you express a view to Mr Del Preti that Crown Perth's request should be supported?
I can't recall.
In any event, to the extent that you asked for an agenda paper to be prepared, and you evidently engaged in some discussion before that with Crown Perth representatives, you did have some involvement in that subject matter of the repeal of the 2010 regulations.
Yes, I did. Nothing to do, no involvement in the decision, however.
Now, I want to take you forward from there. That was 2009, 2010. I want to take you forward to 2017 and open up this document, GWC.0002.0016.0202, and not on the public screens, please. This is an agenda for the February 2017 GWC meeting. And if we go to page 0012, do you see under item 5.1.2, matters to be actioned, there's a compliance review project across all regulated gambling that was to be undertaken at that point. Do you see that? 5.1.2?
I do, yeah.
Yeah. And you had the carriage of this compliance review project, didn't you?
I did.
Yeah. And if we go to page 0013, you had prepared this agenda paper that you provided to GWC members about the what that compliance review project was to involve.
Yes.
And if we look at the second paragraph, junket operations, you'll see in the second line, were an aspect of that review that you intended to review compliance and regulation in respect of. Is that
Correct.
right?
That's correct, yep.
Now, if we go to this document, DLG.8001.0023.7494, this is a document that you prepared in respect of the compliance review about junket requirements, is that right?
Not quite. I didn't prepare this document. This document was prepared for me.
I see, and you reviewed it.
And I reviewed it, yeah.
And that was in February 2017 by a look at the footer in the bottom left-hand corner. Is that right?
To
your recollection?
Yep, to my recollection, yeah.
And so what this does is this document sets out the regulatory regime for junkets as at 2017.
That's correct, yeah.
And the point you make on this first page at about point 4, the fourth dot point there, is that even though the regulations repealed the requirement for the approval of junket operators, in the casino manual there's still some residual directions there for approval, and also for junket participants' names and passport numbers to be provided to the GWC. That was the position that continued to pertain at 2017, is that right?
That's how I understand it, yeah. So again, I'm not making that point. That's come from the author of that paper. I'm not quite sure who that is, but it'd be someone in the inspectorate. Yep.
But that's how you remember
That's how
it.
I remember
I'm not
it, yep.
asking you to tell me
Yep,
what's in the
yep.
document. I'm pointing you to the document in order that you can tell me whether this reflects what the regulatory position actually was at that time.
Yep.
And it was.
Yes.
So the approval requirement in the regs had been repealed. And even though the casino manual continued to say that approval was required, no approval was sought or given as at 2017. Is that right?
I didn't actually talk about approval. As I understand it, it just required the casino licensee to provide lists of names and attendees, not to get a prior approval.
Right. So in any event, as far as you were aware in 2017, no approval was being sought
Correct.
or given.
Correct.
However, Crown continued to provide the names of junket participants, did it?
As far as I'm aware, yeah.
And passport numbers.
As far as I'm aware.
And what was the department doing with those names and passport numbers?
As far as I'm aware, nothing.
Was it filing them?
I guess so. I mean, they weren't coming to me. They were going to officers within the department, but I don't believe that there's actually anything, they're actively doing anything with those, so probably filing those.
Right. But you were the chief casino officer.
I was.
So you would have had some sense of what was going on with junkets and the regulation at GWC.
Well, my understanding was that we didn't approve junkets, and I wasn't going through the manual on a daily basis or any sort of regular basis to look at these sorts of requirements. That's not something that I would have done myself.
But you knew that the names and passport numbers were being provided?
I was aware that that was a requirement. I didn't know that it hadn't been removed from the manual at that point in time, I don't think.
Now, I just asked you this because it's not directly related to what I just asked you, but it comes chronologically in the right order. I just want to show to you, not on the public screen, please, this document, CRW.008.001.3869, and it's an email from you to Mr. Preston of the 15th of May 2014. And you wanted to know if the people you had named in that email were members of the Pearl Room. Why did you want to know that?
I believe that email was in response to a request from the Victorian Police. I believe that was a phone call from an officer in Victorian Police who gave me those names and dates of birth and wanted to check. And I did actually have a conversation with him at the time to say the only way that I can find that out is to actually ask the casino licensee, and they were comfortable with that. I asked the question, and I believe that's what that was.
Right. And knowing that the Victorian Police were interested in these names, did that cause you to have any concerns about those people being held as members of
I didn't know why they were interested in those people or those names, and he wouldn't have told me that. So no, it didn't really raise too many alarms for me.
All right. Now, in September 2014, you recall Four Corners broadcast a program called High Rollers, High Risk.
I don't actually. I thought the first program was actually in 2016. So, but I'm aware now. Yes.
But you say you weren't aware at the time.
I didn't think it was 2014. I thought the first Four Corners report was in 2016 or so.
So you remember a Four Corners
I do.
report?
Mm-hmm.
It might have been 2014 or it might be
Yes.
2016. You remember it as 2016?
Yes, I do.
Do you remember it being, whether it was 2016 or 2014, you saw it at the time?
I absolutely would have seen it at the time.
And you understood it was a program that dealt with the threat posed by organised crime in Australian casinos,
Yes.
and claimed that there was a link between junket operators in Macau and organised crime groups.
Yes.
And one of the points made by the program, you recall, was that Australian casinos that target Asian VIP gamblers could run a serious risk of exposure to organised crime.
On the program, yes.
Now, you gave a verbal briefing to the GWC about the program, didn't you?
I believe so, yes.
And if we go to this document, not on the public screen, please, gwc.0002.0016.0135, which is the minutes of the GWC meeting held on 23 September 2014 at 0003. Your verbal briefing is at 0008. So there's some memory jog as to whether it was 2014 or 2016,
Yep, it is.
Mr. Connolly. You explain in the first paragraph the contents of the program, and then you go on to say that the arrangements for junket operators in Macau are significantly different to those in Australia. And you place some focus on the junket operators leasing and operating gaming rooms within a casino that may include the provision of credit. Why was that significantly different in your mind to Australia in terms of risk of criminal infiltration and money laundering?
Because junket operators in Macau control the room and control the gaming and control the movement of chips. In Australia, that's done by the licensed approved casino operator and the casino operator only.
And so did you conclude from that process of reasoning that there was nothing to worry about in terms of risks at the Perth casino in respect of junkets?
For my part, I concluded that the risks were less in respect of junkets. I think there's always something to worry about, but I think having a licensed casino operator control the gaming, control the movement of chips, and control revenue and tax reporting reduces those risks significantly.
So the point you make in the second last paragraph in this section, you say while junket operators are no longer licensed, you refer to entry to Australia, their entry to Australia being controlled by Border Protection, Department of Immigration, and then the casino licensee having to comply with AUSTRAC and
Yep.
AML legislation. Was your assumption at this time was that those two things were sufficient to adequately mitigate the risk of money laundering or criminal infiltration of junkets to Perth Casino? Is that right?
Yes, yes.
Before the verbal briefing, to the GWC, did you make any inquiries or conduct any investigations into the subject matter of the Four Corners report?
I don't recall.
Did you make any inquiries of Crown Perth?
Honestly, I don't recall.
The Sun City junket was mentioned in the Four Corners report. Recall that?
Yes.
And the Sun City junket had been conducting tours to Perth Casino since 2010, to your knowledge?
Not to my knowledge, but probably, yeah.
Did you look back into the information GWC held about Sun City?
Honestly, I don't recall.
Or ask Crown about its due diligence on that junket operator?
I believe that Crown was asked to provide a briefing to the Commission about their due diligence on junket operators per se, but not just Sun City.
The Four Corners program also mentioned the Neptune Group VIP clients or high rollers being invited by Perth Casino to come over from time to time for functions. You recall that?
I recall it from the article, yes.
From the program?
I read the transcript from that documents last night, so I recall it from that, yes.
And the program mentioned that the Neptune Group was backed by Chung Chi Tai, who was alleged to have triad links.
Yes.
And you were aware that junket operators associated with the Neptune Group had been operating in Perth since 2011?
I wasn't aware of that, no. But that doesn't mean it didn't happen. I wasn't aware of that.
Well, did you look into whether...
I don't recall.
And do you recall whether you asked Crown about its due diligence on entities or people associated with the Neptune Group?
With the Neptune Group specifically, no, I don't recall, but I have asked Crown on a number of occasions about their due diligence around junket operators, and they've presented that to the Commission on a number of occasions as well.
The last paragraph of this section of general business identifies that you were going to prepare an information paper in relation to junket operators for the next meeting. And we'll go to that document now. It's not to be displayed on the public screens, please. GWC.0002.0016.0121 at page 0053. If you've read this agenda paper over the last day or so?
I haven't in any detail, no.
You might recall that it simply provides an explanation about what junkets are and how they work. If we go over the page. And at 0054, the third full paragraph, you identify that the licensee conducts its own due diligence on players. You describe that as for the purpose of protecting its own commercial interests. You see that?
I do, yep.
To what extent did you understand that due diligence involved checking for criminal associations of operators or junket participants?
Sorry, could you ask that again?
To what extent did you understand that Crown's due diligence on junket participants or junket operators involved checking for criminal associations of those participants or operators?
I understood that Crown's checks look at the reputation of players and information that's publicly available. I don't understand that they had any ability to check their criminal associations.
So when we get to the next paragraph, you are talking about the AUSTRAC reporting requirements, excuse me, that the casino licensee is required to comply with. And your reference to that AUSTRAC legislation reflects the position you had had since at least 2012, when you commenced as CCO, that because of that AUSTRAC legislation and the role that AUSTRAC had, the department and therefore GWC had no role in monitoring or overseeing the risk of junkets or high rollers using Perth Casino to facilitate money laundering. Is that right?
That's correct, yeah.
That was something that AUSTRAC was responsible for?
That was my understanding at the time, and it still is.
And department and GWC did not have the means to take on that responsibility?
That's correct.
Nor should it, because it would be duplicating or at least overlapping with AUSTRAC's role and responsibility.
That's correct.
And not only was that your position and understanding until 2019, I think you've just said you still hold that position.
I do, and I actually have advice from General Counsel of the department to that effect as well. Says the role of the Commission is to regulate the gaming operations and has no role to monitor or enforce AML or CTF.
So when you wrote that, though, that
Yeah.
paragraph about the AUSTRAC responsibilities and legislation, you didn't consider that there was anything in the Four Corners report that caused you to reflect on the correctness of your position or understanding?
There was a reflection for sure, but it was, for me, it was more about capacity and who's the right organisation, the organisation with the ability to deal with that. And it certainly wasn't the Department of Racing, Gaming and Liquor or the Gaming and Wagering Commission.
The effect of your evidence on the last occasion you were here was also that through 2014
Yeah.
to 2019, and I presume you'll say continuing to today, that Border Force did and does check a person's criminal history to determine whether they should be given a visa.
That's how I understood that, yes.
And it is therefore a suitable, the checks that Border Force do are therefore a suitable proxy for a decision about whether or not to allow a junket operator or junket participant to come to Perth Casino.
That's how I understood that, yes.
And as a consequence, you considered from at least 2014 until the present day that the department and GWC does not have the means to take on that same responsibility?
Yes.
Nor should it, because it would duplicate or at least overlap with what Border Force's
Yes.
role and responsibility is.
Yes.
There was nothing in the Four Corners report that caused you to reflect on the correctness of that view?
Not that I recall. And I still maintain that view, so I'd say no.
Well, it suggested, didn't it, that people with criminal associations were being permitted to organise or participate in junkets to Perth Casino?
It did suggest that.
So didn't that lead to a question in your mind that maybe Border Force wasn't sufficiently vetting the people who were coming into the country as suitable people to come to Perth Casino?
Perhaps, but certainly the Department of Racing, Gaming and Liquor and the Gaming and Wagering Commission didn't have the ability to vet those people in any meaningful way. Certainly not in any more meaningful way than Border Force.
Well, did it occur to you from the contents of the Four Corners report that the then current practice of Crown providing the names and passport numbers of junket participants might be useful to address that issue?
No.
Well,
In what sense?
they could easily be provided to the police, those names and passport numbers, couldn't they?
They could have, yes. And they had been in the past. Not that anything had ever come from that practice.
Nothing had ever come from that practice?
Not that I'm aware of.
That was before your time as CCO, wasn't
It
it?
was absolutely before my time as CCO, yeah.
But you accept that, at least theoretically, the police could identify whether junket participants had criminal associations that would render them unsuitable to attend Perth Casino?
Yes,
And then you could at least speak to the licensee about that?
yes.
But
Or the
that's-
Commissioner of Police could actually bar those people from the casino himself.
But none of those things as possibilities of action that could be taken occurred to you in the wake of the 2014 Four Corners report?
No. Not that I
Now-
recall. And not that they were decisions for me alone. There were a Gaming and Wagering Commission to consider all of those and all of those other possibilities as well.
Now, I want to come back to this document, DLG.8001.0023.7494. And this is that February 2017 compliance review junket document that you had prepared for.
Yes.
Now, at the bottom of page 7497, I think it is, can we just go to 7496 and towards the bottom? Yes. Do you see the heading corporate junket operators operating at Crown raised by Compliance Inspector Ms. Webb?
Yes.
Now, who is it that's saying they spoke to Vanessa on the 13th of February 2017?
The author of this particular document, I don't know who that is. It's not signed and I don't recall who wrote that.
In any event, you read this document at the time?
Yes, I did.
Yeah. And you understood that what was being explained here was Ms. Webb's concern that she had expressed that the way in which the Jimay Group operated their junket tours raised questions about whether the tours were being used to facilitate money laundering.
Did she talk about money laundering? Can I
Have a
see
look at the last
following
sentence.
page?
Have a look at the last sentence and then I'll take you to the next page. The transactions would be similar to what used to be done by the, quote, bagman, but not by the means of use of printers, laptops,
Yes.
etc.
Yes.
So you understood she was voicing a concern about this tour operating in a way that might facilitate money laundering.
I don't think she's talking about money laundering, but a bagman is a normal process for a junket operator. A junket operator controls funds and issues chips and gets chips back from junkets while they're conducting their play.
So where she has voiced concerns in the past about these groups having their own, basically, facilities, office facilities at the casino, that's precisely the concern you had about the operations in Macau, isn't it?
It is.
Yeah. And that was why you understood Macau to be qualitatively different from Australia in terms of the exposure to the risk of money laundering.
Can I just correct myself just a little? Not precisely. So in Macau, as I understand it, they control the room. A bagman for a junket, he doesn't control the room. They administer the gaming and the players' participation. So they will issue chips and receive chips back. But they're not controlling the gaming. They have no influence or control over the gaming. They're just conducting the business of that junket.
So let's go over the page.
Mm-hmm.
Second paragraph, Vanessa reported that the Lau Group would come to Crown Perth and have exclusive use of one of the salons. Group had been known to leave chips on the table for days at a time. She wasn't aware whether this was still occurring. She said sometimes they'd only bet for half an hour, then they may not bet for 3 hours. Reason wasn't known, but it was noted they received calls that appeared to tell them when to bet, possibly depending on what funds were available. You see? According to Vanessa, it was possible that some junket participants were not genuine players but acting as agents for others.
Yes.
You understood she was raising this because of a concern that this behaviour was indicative of a risk that the Perth casino was being used to facilitate money laundering.
I don't think she's talking about money laundering. I think she's talking about potential breaches of our gaming legislation and people taking instructions over the phone on what to bet on. I don't think she's talking about money laundering specifically. I think she's talking about the way the junkets were conducting their business.
There's a plain risk of money laundering from this activity, isn't it?
There's a risk of money laundering from this activity.
And
yes.
that was apparent to you reading this part of this paper.
I didn't think about money laundering being the primary concern of this paper.
I didn't ask you whether you saw it as a primary concern. It leaps off the page though, doesn't it? that there's a risk of money laundering in this sort of conduct.
There's yes.
And that occurred to you at the time.
It wasn't the first thing that occurred to me at the time, but
But
yes,
it did occur to you at the time.
Yes, I accept that. Yeah.
And so did you have cause to reflect on your position that Border Force and AUSTRAC legislation together was sufficiently mitigating the risk of money laundering at Perth Casino?
Not as a result of this paper.
A few days before, so if we accept that this is 16th of February when this document's produced, a few days before, on the 10th of February 2017, you received a request from Crown Perth for amendments to the casino manual. And if we put this up, not on the public screen, please, gwc.0004.008.005. Now, this letter from Mr. Preston to you refers to a discussion you and Mr. Hume had on the previous day about some amendments to the casino manual.
Yes.
And Mr. Preston is asking for part 16.2 of the manual to be amended. If we go to page 005, you can see there by the tracked amendment, Mr. Preston is seeking to have removed from the manual the requirement for approval of junket operators by GWC to bring it in line with the repeal of the regulations, I beg your pardon. But note here, he is not advocating for the removal of the requirement to provide the names and passport numbers. Do you see it? What's new numbered paragraph 2?
I do, yes.
I suggest that in light of the concerns that you had heard of, that Ms. Webb had expressed in the document produced a few days later, you would have been very cautious before acceding to any request to relax or remove requirements in respect of junket operations set out at this time.
Perhaps I don't recall what I was thinking at that time, but perhaps, yeah.
And we go to this document, CRW.708.008.7829, which is a letter from Mr. Hume to you, dated the 16th of March 2017. You had a further discussion with him by this time about the amendments to the casino manual.
Yep.
And basically the idea is to do some more major amendment to the casino manual in respect of junket operations. Is that right?
I think at the time there was more major amendments to the casino manuals to bring them into a new format as well. This, as I understood it, was part of that.
So if we have a look at 7382. 7832. Thank you. You'll see that part 16 is being removed in respect of junket programs entirely. We go over the page. As are parts 17 and 18. And then if we go to 7856, I beg your pardon. This is a part of a new part 28, where instead of GWC being provided with the player names and passport details, these are provided internally to Crown and forwarded to its legal officer, AML. You see in row 3?
Yes.
Who was that at the time?
I think that was Joshua Preston at the time.
Right. So there was a discussion, was there, between 10 February and 16 March between you and Mr Hume, in which you discussed, amongst other things, discontinuing the requirement to provide junket participant names and passport numbers to GWC.
Yes, I believe so.
In addition to the previous request from Mr Preston to remove the requirement for GWC approval of junket operators.
Yes, I believe so. As an administrative catch-up for the regulation changes, but yes, I believe so.
Had, as far as you are aware, the responsibility for managing this issue with the GWC been transferred from Mr Preston to Mr Hume?
Sorry, please.
Well, you'd got the first letter from Mr
Yep.
Preston, the second letter from Mr Hume, and you'd had discussions with Mr Hume.
Yep.
In addition, had Mr Preston handed over the conduct of this issue on behalf of Crown to Mr Hume
I
at this stage?
don't know.
You were planning a fishing trip with Mr Murray and Mr Hume at this time, weren't you?
Probably.
Or probably, CRW.709.132.6194.
Yes, timing seems to be about right.
Yes. Up to Jurien Bay.
Mm-hmm.
And you think you were planning some skydiving in Jurien Bay with Mr Hume and Mr Murray?
That's correct. Mr Hume.
Well, let's have a look at DLG.8001.0046.1396. So that email goes to Mr Hume, Mr Murray, Mr Preston,
Yes, it
Mr
does.
Nichols.
Yes, it does.
So were you planning skydiving with all of them?
No,
Just Mr Hume?
that's correct.
And I think towards the end of March, you ended up rescheduling that trip. It had previously been planned for the 24th of March.
I believe
and
so.
then it needed to be
I
rescheduled.
believe so.
And by about 29th of March, you were emailing Mr Hume, Mr Murray and so forth to try and reschedule that fishing trip.
Yes, I believe that's correct.
So returning to the discussion we were having a moment ago about the 16 March letter with Mr Hume and the discussions you were having with him about the relaxation of the casino manual, did it occur to you at the time that your friendship with Mr Hume might cloud your judgment with respect to what the GWC should be doing in responding to that request for amendments to the casino manual?
No, it didn't occur to me at the time, and I don't believe it did, but no.
Or that Mr Hume and also Mr Murray might be deliberately cultivating a friendship with you in order to facilitate your approval to requests such as these?
No, I don't believe that happened.
As to the proposal to, in addition to removing the requirement for approval of junket operators, to also remove the requirement for junket participant names and passport numbers to be provided to GWC, was that your idea or Mr Hume's idea?
I don't recall. I don't think it would be mine.
And the fact that what was being proposed was that instead of GWC receiving those names and passport numbers, Crown was required to provide them to their legal officer AML, that's anti-money laundering. Didn't it occur to you at that point that your faith in AUSTRAC to adequately mitigate the risk of money laundering and your faith in Border Force to prevent criminal infiltration into Perth Casino through junkets was misplaced to the extent that Crown itself was identifying a need to have an additional layer of AML mitigation?
No, it didn't occur to me at that point. And I maintained that view and faith in AUSTRAC and Border Force and their liaison with WA Police as well.
Now, 16th of March, you got your letter from Mr Hume where he, with these expanded requirements for removing the names and passport numbers disclosure to GWC from the casino manual. A few days before that, you'd received an email from AUSTRAC, hadn't you? Can't remember?
I believe so, yes.
Let's have a look at it. Not for presentation on the public screen, please, GWC.0004.0019.0026. And if we go to page 0003, so like all these email chains, they start at the back, Mr. Connolly. So the AUSTRAC officer explains to you that there's a campaign AUSTRAC's undertaking to look at casino junkets. Did you review this email over the last few days?
I've seen this email over the last few days, yes.
Yes.
Last night.
Second paragraph. The writer is very clear about wanting to know what GWC as a regulator does, as well as the casino, by way of oversight of junket operations, and whether that extends to probity audits and inquiries. You see that?
Yes, I do.
And asks specifically in that last sentence in the second paragraph whether there are any regulatory changes proposed in this space, which of course for GWC at this time there was, wasn't there? Because you were actively discussing with Crown whether to remove the requirement for names and passport numbers of participants in junkets to be provided to the GWC.
Yes. I'm not sure I would have seen it as that, but yes, I agree with you now. I don't know if I would have told AUSTRAC that, given AUSTRAC that information, but...
Well, you clearly should have, because it's
Perhaps
plain,
I should have, yeah.
isn't it?
Mm-hmm.
Yes, it's plain, isn't it?
But yeah, I agree, yes.
Now, you respond after the writer chases you up on the 4th of April. If we go at 0002, let me just show you so you have the sense of your email at 0001. This is your response, which you've read recently. And if we go over to page 002, thank you, operator, at the penultimate paragraph, there has been considerable media and interest around junkets. That's what you say there.
I do.
So you were aware that at the time that concerns were being raised in the media and elsewhere about the risks of criminal infiltration of junkets, weren't you?
I was.
And the use of casinos by junkets to facilitate money laundering.
Yes.
You go on to say that currently, if you can just pop that back, please. Oh, sorry, thank you. You go on to say that we, and that's a reference to the department, GWC, isn't it?
We are currently conducting a review, is that where we're looking?
Yes.
Yes.
Of compliance activities in that space,
Yes.
with an interim report expected to be provided to the GWC that month. That was April.
Mm-hmm.
But you hadn't done anything, had you, at this stage to advance that interim report?
Not that I'm aware of, not that I recall.
So what was the basis for saying that to AUSTRAC?
Well, it was planned.
And you say at this point, I can't tell you what some of those changes, if any, may be. Well, you could have frankly said...
We've removed passport requirements for passports. Could have said that.
Or that the casino has asked us to and GWC is considering.
I could have said that, yes.
So why didn't you?
I don't know. That was 2017. I don't know what I was thinking at that point. But I don't know. I could have.
Coming back to AUSTRAC wanting to know what regulators do by way of oversight of junket operations and whether that extends to audits and probity inquiries, you appreciated at the time, didn't you, when you received the email from AUSTRAC, that it was assuming that at least some of the casino regulators in Australia were or might be doing their own probity inquiries of junket operators?
Yes.
And that AUSTRAC, therefore, did not assume, as you did, that probity inquiries by casino regulators was something that regulators did not have the ability or means to do or would overlap with what AUSTRAC was doing.
So I don't know what other jurisdictions were doing in particular, but I'd suggest that from previous experience and discussions I'd had with them, that they were doing things that we had done in the past, asking for things like a National Police Clearance Certificate as part of a probity investigation. Whether there's any value in that, I seriously doubt it.
This email from AUSTRAC talking about this campaign and inquiry that it was undertaking didn't change your attitude to the position GWC should take regarding the amendments to the manual that were under consideration at that time?
No.
Now, after you received Mr Hume's letter of the 16th of March 2017, you attended an operations meeting with Crown Perth people on the 30th of March, didn't you?
I believe so, yeah.
If we go to those minutes, CRW.700.001.0167, at page 0169, (2.12), do you have it?
Yes.
With reference to the proposed amendments in respect of junkets, CLO advised that the proposed amendments to the above procedure had been recently lodged for the GWC's consideration. That's a reference to them having been provided to you.
Yes.
And then at CRW.709.118.5925,
Yes.
there's an email from Mr Hume on the 10th of April inviting you to a pizza and movie night on the following Thursday, the 13th of April.
Yes.
And the next day after receiving that email, that's the Tuesday, you approved the amendments to the casino manual under delegated authority, didn't you?
I believe so, yes.
Well, let's have a look. GWC.004.008.004. 11th of April, your letter to Mr Preston. And you say in the second paragraph, you've determined to approve the amendments and enclose the instrument of approval and finalised copies of the amended manual or parts of the manual. If we go over the page, please, to the delegation instrument, also dated the 11th of April, you have exercised delegated authority as CCO.
That's correct.
You did not raise with the GWC these amendments for their consideration and obtain their approval of the amendments before exercising your delegated power, did you?
I would, no.
And that was contrary to your practice at the time, wasn't it?
Not for all things, no. So I didn't prepare these documents. They were reviewed by officers within the department. Officers prepared the documents for my signature, so I'm not the only one looking at these. They do go through a process and officers look at these. In my assessment, that didn't need to go to the Commission. They are reported to the Commission. The fact that I have done that is reported to the Commission in a following and subsequent meeting where I've exercised my delegation. Officers prepare an agenda paper to advise the Commission, and if the Commission have questions, they can ask questions of me then on those approvals.
Was it the case that you were expected to exercise delegated authority on any given occasion only after the GWC had specifically approved you doing so?
No, I don't believe so, if I understand the question correctly.
Would you like me to ask it again?
I think I would, yeah.
Was it the case that you were expected to exercise delegated authority on any given occasion only after the GWC had specifically approved you doing so?
No, I think I had the ability to exercise delegated authority, as I saw.
And I want to take you back to your witness statement that you filed in these proceedings,
Yeah.
MCN.001.000.0039. Page 0051, paragraph 100. Under the heading of delegation of power, you describe, after paragraph 100, the ordinary practice you have always adopted since receiving this delegated power. And if we look at 101, a matter, whether that, amongst other things, be a change to policy or the introduction of a new game, would ordinarily end up as an application that requires a determination to be made by the GWC. You would accept, wouldn't you, that an amendment to the casino manual would be included within the sorts of matters you're describing at paragraph 101?
No, I don't think I would. In paragraph 101, I'm talking about Gaming and Wagering Commission policy on different matters and a new game. I don't think that the matters that we're talking about fit into that.
Well, it's amongst other things. That's why you've used the expression inter alia, isn't it? It's not just a change of policy or an introduction of a new game that you're referring to.
It's not just a change of policy and introduction of a new game. I can't think of an example off the top of my head, but it's not everything. Otherwise, I would have said, as a matter of, I seek permission from the Gaming and Wagering Commission before I determine anything under delegated authority.
Well, it's a matter.
It is a matter.
Whether that be, amongst other things, a change to policy or the introduction of a new game, would ordinarily end up as an application that requires a determination. Well, you would accept that Crown was applying to you for an amendment to the casino
Yes, I would.
manual, and
Yes,
the
I would.
GWC needed to make a determination about that.
Well, somebody with the delegated authority, be that GWC or someone, had to make a determination on that.
So it fits within the ordinary practice you've identified at 101.
There are matters that I have exercised delegated authority on without going to the Gaming and Wagering Commission. And again, I'm struggling to think of examples of that off the top of my head, but obviously this is one, yeah.
So at 103, you say, then I will then work constructively with the Department and Crown to ensure that by the time an application is made, it's in a format that allows the GWC to understand and consider it. You didn't do that on this occasion?
No, I didn't. No, I did not.
104, 105 is reference to, in effect, drawing an agenda paper. You didn't do that on this occasion?
No, but again, the matters are reported to the Commission, even though not beforehand. The use of the delegated power is reported to the Commission, and the Commission has the opportunity to interrogate that, should they choose to.
We go on to 108. Once that agenda paper has been considered by the GWC, it then approves or rejects that application in principle, I would then give effect to that decision through using my delegated powers. That didn't happen on this occasion.
No, it didn't.
You exercised the delegated powers first.
Yep.
Why?
Because it was a matter that I believe that I had the ability to exercise the delegated powers on. I think when I'm talking in the statement here, and I would concede it's not as clear as perhaps it could have been, I'm talking about new games, changes to policy, changes to direction that would go to the Gaming and Wagering Commission first, not what I would see as administrative type functions in cleaning up manuals.
Now, I want to take you to your transcript on the last occasion. It's PDF page 35. I'm sorry I don't have the exact page number for the operator, but it should be the 35th PDF page on that day's transcript. Yes, thank you. So we're at transcript page 248. Now, do you see at line 35, you tell me that the Chief Casino Officer is a very limited role. Revolves around licensing, casino employee licensing and functions within the department. You see that?
I see that, yes.
How then did you think that you could exercise delegated power as CCO to approve the amendments to the casino manual without reference to the GWC?
So I think in that paragraph, I'm talking about the legislative role of the CCO. So within legislation, the CCO has very limited powers, but the powers delegated to the CCO and to me as the Deputy Director General are more extensive.
Did you decide to exercise delegated authority on this occasion without reference to the GWC first because of your friendship with Mr. Hume?
Absolutely not.
As a favour to him?
Absolutely not.
Just to confirm, Mr. Connolly, you remained of the view as at 2017 that there was no benefit in retaining in the casino manual the current practice of Crown providing the names and passport numbers of junket participants to GWC because you considered that AUSTRAC was doing the job adequately,
Yes.
as was Border Force.
Yes.
And despite what Vanessa Webb had said to you,
Yes.
and despite what AUSTRAC had said it was doing in terms of an inquiry into junket regulation.
AUSTRAC was asking us what we did, and they were told what we did. They gave a presentation to AUSTRAC at one point in Melbourne and what we did, and reaffirmed my view and the Gaming and Wagering Commission's position in regards to AUSTRAC. So they weren't suggesting to us that we should do other things. They were simply asking what we did and what we didn't do.
Did you check or consider before exercising delegated power on this occasion what other casino regulators were doing at the time in Australia?
I believed I had a reasonable understanding of what they were doing already in Australia at that time.
In particular, were you aware whether or not the Victorian regulator was approving junket operators or participants?
I don't believe they were at that point in time.
Were they receiving information about junket participants?
I don't know.
There were limits to your knowledge of what other regulators were doing?
Yes, there were.
So did you check, therefore, at the time, before exercising delegated power?
No, not before exercising that delegated
Well,
power.
why not?
Because it didn't occur to me at the time to do that.
Well, surely it would be relevant to your consideration of the request to consult with other regulators to make sure that your assessment of the request as being adequate and correct was consistent with what other regulators were doing.
It didn't occur to me at the time. No, I didn't do it.
It didn't occur to you that it might be prudent to await the outcome of AUSTRAC's inquiries before making any regulatory changes?
No, and certainly the outcome of AUSTRAC inquiries could inform regulatory changes and revert those back. Nothing in that would have been set in stone, but no.
You wrote to AUSTRAC in the following week after you exercised delegated authority in favour of Crown. So we go to this 18 April document, which is not for publication on the public screens, GWC.0004.0019.0008. You're setting out in letter form the position in WA in similar terms to your email to AUSTRAC on the 4th of April. If we go to page 0002, you're explaining from the third paragraph about the circumstances leading to the repeal of the regulations in 2010 and how that was based on a national competition policy review. And then if you go to the fifth paragraph, that's the one that commences the review concluded. You articulate the conclusions of the review from a competition point of view, that the approval process could be removed without affecting the primary objective, and you understood the primary objective of the approval process was to ascertain whether junket operators and participants had any criminal associations.
That's how I would understand it, yes.
And were otherwise suitable to participate in junket tours to Perth Casino.
Yes.
And you understood that the reason the review concluded that the approval process could be removed without affecting that objective was because, on your understanding, the review considered that rigorous checks of people coming in via junkets to Perth Casino were conducted by appropriate regulatory authorities,
Yes,
which you understood to be AUSTRAC and Border Force.
yes,
And you yourself don't know what Border Force checks
I don't.
entailed. I think we established that on the last occasion. And you had assumed that up to this point they were rigorous
Yes,
without checking that yourself.
no.
And you made the same assumption about the
I would have. I thought that would have been a reasonable assumption, though, that Border Force and AUSTRAC are, when they do checks, they do rigorous checks.
You made the same assumption about AUSTRAC, that they were rigorous checks, although you didn't know what those checks were.
No.
Now, you informed, I beg your pardon, GWC was informed of the amendments to the casino manual in the agenda for the 23 May meeting. You recall that?
I'm aware that that's happened, yes.
Let's go to it.
Yeah.
Not for publication on the public screens, please, gwc.002.0016.022 at page 0093. So it looks as if this document is prepared by Nicola Perry, looking at the footer, Mr. Connolly. Do you remember whether you prepared it or?
It's prepared by officers, not by me.
Did you check this paper before it was given to GWC members?
I would have read it before it was given to members.
So in the second box,
If I was at that meeting, and I don't know if I was, but I'm assuming that I was at that meeting, I would have read the papers before they went.
so you see the second table and then the second row of the second table?
Yes.
Casino Manual Operations, International Interstate Gaming Business News section. And
Yes.
the details of the approval that had been given under delegation, got a new section 19 inserted, it tells us. And the second sentence, requirement for junket operators to be approved by GWC has been removed in line with regulations that were previously amended in 2010. It doesn't refer to the other information requirements being removed, though. You see that?
I do.
Well, what's the reason for that?
I don't know. I didn't prepare the paper, and it probably just didn't. That penny didn't drop with me when I read that. So I don't know.
An oversight.
I would suggest an oversight.
Now, you attended the subsequent meeting of
Yes.
the GWC members. Did you tell them in relation to this approval that you had given under delegation about the concerns Vanessa Webb had expressed around junkets as reflected in the draft February review paper?
I believe I had that conversation with the Director General, and the concerns that Vanessa Webb had raised, I'd asked, in response to that, I asked for a GWC agenda paper to be prepared, for that to be investigated, and if that was happening, a paper be prepared for the information of Commission. That didn't come, that nothing eventuated from that. So I assumed that there was no issue that was actually taking place there, that there was nothing to report to the Gaming and Wagering Commission.
Right, and the Director General that you're referring to there that you spoke to was Barry
Barry
Sargent.
Sargent, that's correct.
Right. Now, did you tell the GWC in their meeting in the May, with reference to this approval you had given under delegation, that AUSTRAC had been in communication with you requesting information about the method of regulation of junkets by the GWC?
I don't recall if I said that at the meeting. I would have had that conversation with Barry, though.
Were the GWC members told at any time about your interactions with AUSTRAC in 2017?
They'd certainly know. I believe I did, and they would certainly be aware of that in terms of travel, because there was expenditure for travel to go to Melbourne in 2017 for AUSTRAC as well, which the GWC would have paid for.
I refer to this document, it's not for publication, operator, it's gwc.0004.0019.0025. And if we go over the page to 0002, you can just get the sense from the email header at the bottom of page 1, Mr. Connolly, that this is an email from AUSTRAC to you in response to your 18 April letter. And amongst other things, what AUSTRAC wants to know specifically from you is what information about junkets that Crown provides to the regulator. And your response is at 0001. We're just going to the second dot point. We receive no AML information. That's money laundering or anti-money laundering information. It's been our understanding we're not permitted to ask for it, and Crown are not permitted to give it to us. You're referring there to the information that Crown provides to AUSTRAC, are you?
Yes, I am.
Notification of suspicious transactions that are required to be reported under Commonwealth legislation.
Yes, that's correct. And normal financial transaction reports as well.
But you obviously appreciated that you could receive other information from Crown relevant to whether and how a junket should operate at Perth Casino that bore relevance to money laundering risk, didn't you?
Yes.
That could be reported by the regulator, that is GWC, to law enforcement agencies, didn't you?
Yes.
That is whether an operator or a participant had a criminal record, for example.
Well, we wouldn't know if they had a criminal record.
You would if you asked WAPOL.
Yes.
Or criminal associations. That information could be passed on.
Presumably, yes.
If you had junket participant names and numbers and you ascertained from WAPOL any criminal associations.
Yeah.
Whether the manner in which a junket is being conducted suggested a risk of money laundering.
So just I'm sorry, but I'll just take you back to the previous question about the names. And that was the practice prior to 2010 when police were involved in those processes, and effectively they provide an opinion on suitability. The Gaming and Wagering Commission moved away from that. From my view and my perspective, they moved away from that for a reason. Why would they reintroduce that and go back to a previous practice which they've abandoned and changed the regulations in 2012?
Your point being, though, you don't need to do that because you've got Border Force and you've got AUSTRAC.
Exactly, yeah.
And there was nothing that you had heard of yet that shifted your view that, well, maybe my confidence in Border Force and AUSTRAC isn't as it should be, is misplaced.
Certainly I didn't see a more practical alternative to that approach.
Well, how about this? You have inspectors on the floor, and if they see large amounts of money in cash being passed through the cage, but only a small amount of that cash being gambled, that might be indicative of money laundering.
It may be, yeah.
And that could be reported to WAPOL or a regulatory authority.
But junket operators generally don't bring large amounts of cash. They're transfers through the banking system. But yes, it could be.
Persons located overseas appearing to gamble large amounts of money by giving instructions to a junket participant by telephone might raise a risk of money laundering.
Mm-hmm.
Yes?
Yes.
And that could be observed by casino inspectors and reported to the appropriate law enforcement agencies. Yes?
Perhaps, yes.
Yes. And it wouldn't be beyond GWC or the department's capabilities to do that.
Yes.
It's a convenient time, Commissioner.
Mr. Connolly, we will take morning tea now. We will return at 11:30. So we'll take a break too. Thank you. We will now adjourn. All rise. you. Please be seated. Okay.
Thank you, Commissioner. So we're back on this email for the transcript GWC.0004.0019.0025 that I had you at before the morning break, Mr. Connolly. And can I take you to your fourth dot point in your response to AUSTRAC? The compliance review is still ongoing, you say. Was it at this point?
As I say, not in any meaningful way, no.
Had any work been done to progress it since you had last advised AUSTRAC of that review?
No, not that I believe.
And you explain in this fourth dot point, the second sentence, the scope of the review will include review of what we currently audit, what we don't, whether there's a change in focus required, what we can do with respect to overseas players, what is or should be the role of police and other agencies, and a review of company structures used by junket operators.
Yes.
So what you were intending to convey to AUSTRAC here was that GWC was looking in a very open-textured way about whether and what it should change in relation to its junket regulation.
Yes, that's right. So what I was getting at there and what I was talking about was a proposal around a national framework. That's what I was thinking about at that time. And I think that comes up a little bit later on.
Well, you don't mention that.
I don't, no.
No. And instead what you are talking about is what we, that is GWC, currently audit and what you don't.
That's correct.
In relation to junkets.
Yep, that's correct.
Right. And the answer was you didn't audit anything in relation to junkets at that point. Is that right?
Not quite. Revenue, tax, the gaming turnover, yes. But in respect of probity suitability, who those people were, no, nothing.
Well, in respect of the things that AUSTRAC was interested in.
That's right.
There was no audit.
Correct.
Right? And whether there should be a change of focus, whether GWC itself, not as part of a national effort, but GWC itself should change focus.
Well, in my mind, I was thinking about a national framework for that and how the GWC could be a part of that rather than doing all of those things itself, and understanding what the GWC's role was in context of what everybody else is doing.
Well, you go on to say, what can we do with respect to overseas players, we as the GWC? So were you questioning at this time in your own mind the validity of your previous rationale that AUSTRAC and Border Force were effectively covering the field?
No, I don't believe so. In my own mind, I was thinking at that time about a national framework. I still don't believe as of today that the Gaming Wagering Commission, the department, has any ability to look at overseas players.
Well, you go on to say what is or should be the role of police and other agencies. And as we went through before the morning break, the GWC could obtain information from Crown about its junkets.
It could.
That could then be passed on to the police for the police to do things with that.
It could.
Yes. So that's plainly something that the GWC could do, isn't it?
Yes.
And when you're talking about what we can do with respect to overseas players, you were plainly contemplating whether or not GWC could be involved in assessing probity. Isn't that right?
I'm still of the view that we wouldn't have the capability, the capacity to assess probity, but what we could do is potentially provide names to police. That would be the extent of that, I would have thought, at this point.
So you must have been contemplating, therefore, when you wrote this to AUSTRAC, that perhaps Border Force was not covering the field in vetting the suitability of people coming in on junkets to Perth Casino.
What I think I was contemplating at that time, that was the formulation of the idea of a national framework, and what I think I was contemplating was identifying quite clearly what everybody's roles and responsibilities were, and having an understanding that AUSTRAC, Border Force, Department of Home Affairs are the agencies responsible for letting people get into the country. if they're appropriate to be in the country through their assessment, then they can come and gamble at casinos.
Yes, but on your existing rationale at the time,
Mm-hmm.
if Border Force was covering the field and AUSTRAC was covering the field, there didn't need to be a national framework.
Well, there was enough media and attention around this to make, what I wanted to do was clarify and articulate quite clearly who was responsible for what. So the Gaming and Wagering Commission and the department weren't being held accountable for things that they couldn't possibly do.
But it was clear in your mind.
It was clear in my mind. It wasn't clear in everybody else's mind.
Who else?
Well, certainly there was pressure from media about what our role was.
And who else?
I don't think the Gaming and Wagering Commission was totally clear on those positions as well.
Do you mean the members?
Members, yeah.
Had you not articulated it?
Yes, I had. Yes, I had.
So how were they not clear?
Well, I don't think, not everybody agrees with everything that's articulated, and I don't think there was complete agreement on those. And I don't think, with respect to the GWC members, that some of the members actually understood all of the information that was being provided to them.
And did you see it as your role to make it clear to them?
So it was my role to try to make it clear to them. Certainly,
Did you do that?
I believe I've made my position, my view clear to them, yes.
Right. Now, just finishing off on this fourth bullet point, you say at the end of that second last sentence, in terms of what this review is covering, and a review of company structures used by junket operators. You had some concerns around the company structures used by junket operators, didn't you?
I put that in there as a result of the information, as a result of information provided by Vanessa, and as a result of what I knew about junket operators, stock market listed junket operators operating in Macau.
You had some concerns around the company structures used by junket operators, didn't you?
Again, I had concern. I wanted to cover off on those points that were raised by Vanessa Webb, and to make sure that we didn't have the same situation that was happening in Macau.
Wasn't it the case that you were concerned that if a junket operator used a company structure rather than an individual, it might make the detection of criminal associations of junket operators more difficult?
That's not what I thought at the time.
Now, you say finally in this bullet point, none of this work has been completed in any meaningful way at this time. You recognised that it needed to be, though, didn't you?
Yes, I did.
You recognised that it was very important for a compliance review to be undertaken with respect to junket operations,
Yes.
as you've described here,
Yes,
to ensure that GWC was appropriately monitoring and addressing the criminal risks associated
Yes.
with junkets, and addressing whether junket operators and junket participants were suitable to come to Perth Casino to gamble. It was important that GWC was regulating that properly.
it was important that the GWC were comfortable in the assessment process and understood who these people were, and that they had been assessed through a suitable process, whether the GWC did that or somebody else did that. But they had to have comfort in that process.
So this, you're explaining this compliance review in respect of junket operations to AUSTRAC at June 2017.
Mm-hmm.
But this was the review that you had been envisaging since February, is that right?
It's correct.
Yes. So why did you not wait until that review had been completed before removing the casino manual requirements for the names and passport numbers of the junket participants to be provided to GWC?
Again, I didn't see that as a significant issue as part of the review, and the review hasn't been completed still. To my knowledge, there is no final complete review of junket operations still.
The compliance review between February and June was contemplating an in-depth look at whether what GWC was doing in respect of junket operation was sufficient,
Yes.
wasn't it?
Yes.
So on what view could you have taken the step before that review was complete of further relaxing the requirements in the casino manual, Mr. Connolly?
Well, at that point in time, there was no purpose to gathering that information because we weren't using it. It wasn't being used.
But surely the compliance review could have looked at whether there could be a use to which that information could be put.
And if it did, we would have asked for it again. But at that point in time, we weren't using it.
It was quite imprudent of you not to wait, wasn't it, until the compliance review was finished before amending the casino manual?
Well, it's still not finished, so they would have still been providing that information to us and not being used for the last 4 years.
The fact of the matter is that if the compliance review had been completed, it might have shown you that the information should continue to be disclosed to GWC and perhaps even further strengthened.
It may have.
I want to show you this document, gwc.0004.0019.0012, an information report that you were provided by AUSTRAC by email on the 17th of July 2017, weren't you? Mr. Connolly,
Yes, I guess. I don't recall getting the email, but I'm sure I did, yes.
you remember receiving this
I remember seeing this.
report
Yeah, I remember seeing this report
in July 2017.
some time ago. So July, it's dated July 17, so yes.
And you reviewed it carefully at the time?
I read it, yes.
Did you review it carefully at the time?
I don't recall. I read it.
Now, on this first page, in the information summary box, do you see numbered paragraph 3? Many junket business models involve international movement of value that circumvent transaction reporting
I do,
requirements.
I see that.
So immediately it was headlined to you that your faith in AUSTRAC in being able to detect and regulate AML risk was misplaced. You'd agree?
With the benefit of hindsight now, yes, probably I would agree. I didn't see it that way then.
Well, you must have seen it that way at that time, Mr. Connolly, because it's set out in black and white, isn't it?
Yes, it is.
Yeah, and that's what you did appreciate at the time, didn't you?
Well, I appreciate that that's what AUSTRAC was saying at the time, yes.
Well, AUSTRAC was telling you in terms, wasn't it, that your confidence that AUSTRAC was effectively monitoring money laundering risks was misplaced. That's what you understood them to be telling you.
No, I don't think that's what I understood them to be telling me.
Have a look at numbered paragraph 4.
Yep.
Over-reliance on the due diligence undertaken by the Department of Immigration and Border Protection when processing visa applications of junket participants also poses a money laundering terrorism financing risk. You understood that what you had been doing up to this point and what the department and GWC had been doing was over-relying on the due diligence undertaken by the Department of Immigration and Border Protection. Yes?
I would concede that, yes.
So it must have occurred to you, even just reading the summary on the front page of this report, that there might be reason to reinstate the approval and information requirements that had been removed from the casino manual and by the repeal of the regulations.
No, it didn't occur to me at the time.
So let's go to the background. If we just shrink the page back, please. And we look at the second dot point. It's telling you that various agencies in the states, territories of Australia and in the Commonwealth have increased their interest in international junkets over the last 12 to 24 months. The second bullet point tells you that one of the reasons why is the increasing awareness that junkets are high risk in terms of money laundering and increasingly feature in investigations in respect of money laundering and proceeds of crime.
Yes.
Now, you could be in no doubt, I suggest, from this point that there was a risk, indeed a high risk, of junkets coming to Perth Casino being associated with criminality and money laundering.
A risk, yes.
high risk. That's what you're being told,
Yes.
Mr. Connolly.
Yes.
But that's what you knew
Yes,
as of July 2017.
yes, and that's what the Gaming and Wagering Commission knew as of July 2017.
We'll come to that in a moment,
Sure.
Mr. Connolly. Let's go to 0003 in section 3. The regulation of junkets. 3.1 discusses the Commonwealth legislation, the AML-CTF Act. And can you see down the bottom of the page, the last two sentences? And what it's talking about here is how the reporting happens under the name of the operator to AUSTRAC rather than under the name of individual participants. It says, this means that all reporting on these transactions occurs only under the operator's name and not the financial activity of individual participants. This is a significant money laundering, terrorism finance vulnerability for junket operations. So again, you're being told very squarely that there are risks of money laundering not addressed by the AUSTRAC regulatory regime. You'd agree with that?
I'd agree with that.
And that's what you understood at the time?
Yeah, I'd agree with that.
And then if we go over the page to 0004, section 3.2 deals with state-based regulation and discusses that. You see the second paragraph, AUSTRAC found that there's inconsistency between the states and territories in relation to the extent of junket oversight they undertake. See
Yes.
that?
Yes.
Were you aware of that?
Yes, inconsistency?
Yes.
Yes.
Had to be because you told me a
Yes.
while ago that you
Yep.
kept yourself somewhat informed about what regulators were doing.
Yes.
Were you bothered by that inconsistency?
Bothered? I think I accepted the inconsistency that was happening. I was aware of it.
We have a look at the table which assesses the position in the relevant states and the territory, Northern Territory, that have casinos and therefore casino regulation.
Yes.
And you'll see from that table that the WA regulator has the least oversight of any of the jurisdictions, in the sense of only following one of the 5 oversight activities, that is reviewing casino procedures. You see that?
Yes.
And it goes on to say underneath the table, I'm sorry, before I go there, you were aware, were you, before you received this report, that WA didn't do many of the oversight activities that other jurisdictions did?
Yes.
And what was the rationale for that?
Again, the Gaming and Wagering Commission had moved away from those oversight activities in 2010 and made a decision to do that.
So you, as Chief Casino Officer since 2012, now 5 years down the track in 2017, hadn't turned your mind to whether that position should be revisited in light of what was happening in other states and the Northern Territory?
Well, I wouldn't turn my mind to it as the Chief Casino Officer. Again, I saw that as a very limited role, and I don't think... I turned my mind to it as Deputy Director General, and I saw those inconsistencies, which is why I wanted to progress the idea of a national framework to address those inconsistencies and have regulators get together and agree on what an appropriate framework, approval process and framework look like for junket operators.
Underneath this table, the next paragraph, it says several state-based regulators are in the process of reviewing their supervisory activities in the junket space. Now, that included WA, didn't it? Because you were telling AUSTRAC about the compliance review that
That was certainly
being
the plan for
undertaken.
WA, yes.
Right. And it goes on to say, some indicating that they will increase their due diligence in relation to junkets. You hadn't flagged that, though, to AUSTRAC.
I had not flagged that, no.
In fact, WA had recently relaxed
Yes.
its requirements. and was awaiting a completion of a review, compliance review, as to whether it would increase due diligence or not. Is that a fair way to put it?
I think that's a fair way to put it.
And then if we go back to the table, you'll see that Victoria receives junket participant details. You see that?
Yes,
And Crown Melbourne operates in Victoria, obviously.
yes.
So what was the rationale for your approval under delegated authority of Crown Perth having to provide the details of junket participants when Crown had to do it in Melbourne?
Again, we weren't doing anything with them. So in Melbourne, Crown, the VCGLR have an on-site presence with the police as well. So presumably they're sharing those details with police. I don't know. But we weren't doing anything with them at the time.
Well,
So
why
my
not?
rationale-
Why not do exactly what was happening at Crown Melbourne?
I honestly, I don't know. I can't answer that question.
Now, if we drop down to the third paragraph under the table, do you see it commences while JTO, that's junket operators,
Yeah.
representatives and participants' details are likely to be provided by casinos to state-based regulators. It then goes on to say the use and dissemination of these details is limited, and recognises in the next paragraph that information sharing across jurisdictions could be difficult. Now, notwithstanding those caveats that AUSTRAC has identified in the report, surely at this point it must have caused you to reflect that the decision made a couple of months before to remove the requirement to receive junket participant information should be kept in place until further investigations had been undertaken by GWC.
Well, it didn't. What it did do was firm up again the idea of a national framework to make sure that everybody is doing the same thing, that information sharing protocols, MOUs and whatever agreements are necessary are in place, and everybody is aware, is doing the same thing. There is a consistent framework and a national framework for junket operators. That for me was going to be the answer to these problems.
Let's go to 0006 at section 4.4. This is the section that deals with over-reliance on the due diligence undertaken by Border Force. You see the second sentence in that section. Several of the entities engaged by AUSTRAC for this campaign, both casinos and regulators, indicated that they place heavy reliance on the probity undertaken by DIBP when granting junket participants their visas. Well, GWC was one of those entities, wasn't it?
Yes.
And the third sentence, these entities argued that if DIBP is prepared to issue a visa to allow the individual entry into the country, they must be of sufficiently good character to engage in a junket. That was absolutely your position, wasn't it?
It was.
And you told me earlier this morning that that remains your position.
It does.
Yes.
In the absence of any better solution at this point in time.
Well, you didn't give me that qualification this morning, so
Okay.
let's go down to what
Okay.
it's then said next. Over the page, please. AUSTRAC contacted Border Force to determine what due diligence was undertaken during the visa application process. And you see there that AUSTRAC is doing what you, I think, frankly acknowledged on the last occasion you had never done, which was actually find out what was involved in the Border Force due diligence process. And what you are told there, that is unless an applicant for a visa self-declares a criminal history or Border Force has got a relevant information holding about that person, they don't request police clearance certificates.
Yep.
And the next paragraph, given the high risk of money laundering risk associated with junket activities in comparison to other tourist activities, wholly relying on Border Force's tourist visa processing practices is unlikely to be sufficient to effectively identify high-risk junket participants. Then plainly, therefore, AUSTRAC considers the heavy reliance on the due diligence undertaken by Border Force to be misplaced and to constitute a money laundering terrorism financing vulnerability. That you knew after reading this report.
Yes.
And together with what AUSTRAC told you in this report about the deficiencies in the suspicious matter reporting to AUSTRAC, because it didn't encompass individual junket participants, you understood that the entire underpinning of the deregulation of junket activities from 2010 through to 2017 in Western Australia was misplaced. Isn't that the case?
It should have been the case. So
Well,
yes.
it was the
Yes.
case, Mr.
Yes.
Mr. Connolly.
Yeah.
You've told me on
Yes.
more than one occasion now that even today, as you're sitting here, you say we shouldn't be regulating junkets here in Western Australia because Border Force
Yes.
and AUSTRAC are doing the job.
Yes.
You were told in July 2017 that that is not the case.
Okay. Yep.
And that is what you understood from July 2017. Isn't that so?
Yes.
Now, if we go over the page to 007, yes, section 5, 0007, we're already there, I beg your pardon. Section 5, opportunities for risk mitigation. Section 5.2, it's advocating for greater collaboration between state and Commonwealth regulators, and talks about in the AUSTRAC being in the process of negotiating memoranda of understanding to receive information from regulators. Now, you understood that that would require GWC to actually collect information if it was going to go down that path?
If it was going to go down that path, yes.
Now, this is July 2017, Mr. Connolly. Mr. Ord has started in the position of Director General by this time. Do you say you shared the report with Mr. Ord?
I certainly would have had discussions about him with this report in our regular meetings, yes.
Did you watch his evidence to the Commission?
No, I
yesterday?
did not.
He says that the report was not shared with him.
I don't know what to say to that.
Did you share the report with Mr. Sargent?
I don't recall.
Do you say you shared it with the GWC members?
I would be very surprised if I didn't, but I don't recall actually doing it.
Well, Mr. Connolly, it would be remarkable that you didn't recall,
Yeah.
given that it turned on its head the entire basis upon which junkets were being regulated in WA to this point. Would you agree?
Yeah, I would agree, yeah.
So I suggest to you that you didn't disclose it to them.
Okay, unless there's evidence to prove that I did, certainly it wouldn't have been something that I was willfully hiding from them. It would have been, I don't know. Honestly, I can't explain that. I can't explain it.
Well, let me ask you about that, Mr.
Yeah.
Connolly. You accept, don't you, that having received this report
Yeah.
and how fundamentally it challenged the basis upon which decisions about junket regulation had been made
Yes.
in Western Australia
Yes.
over the then last 7 years. It would have necessitated you bringing forward an agenda paper to GWC, squarely putting the contents of this report to the GWC and advocating for an immediate review of junket regulation in the state.
That's what should have happened.
And it didn't, did it?
I don't know. I don't recall it happening, so no, I don't think I did. I would have recalled that. But certainly this would be, again, why I was pushing the idea of a national framework.
Well, let's move away from the national
Sure.
framework and ask about the compliance.
Sure.
What was happening with that in July 2017,
So-
Mr. Connolly?
July 2017 was a fairly tumultuous period in the department, and the period after that, that was the period of machinery of government changes, as you correctly point out when Mr. Ord took over. At that point in time, I took on a range of new responsibilities. Every day was a triaging exercise. So the review hasn't been completed.
The review as at July 2017, in light of this report, had now become not just important but urgent. Would you agree?
I would agree, but there were also a range of other inquiries that were going on nationally into these subjects. Inquiries in Victoria, not too long after there was the Bergen inquiry in New South Wales looking at all these, and the position was one of holding and seeing what happened as a result of those inquiries.
But you had been told squarely that WA's regulation was the least of all the casino states, if I can put that. Casino jurisdictions.
Yep.
So it was incumbent, wasn't it, on GWC and through you as the Deputy Director General and Chief Casino Officer to address that.
It should have been.
As a matter of urgency.
It should have been. I would accept that's a failing on my part.
And you were aware, because you mentioned it a moment ago, that there was media interest at the time around this topic.
Yes.
So it's not as if it was something that didn't need attention. The community was clearly interested in it.
Yes.
You would accept?
Yes.
Now, in terms of your interactions with Crown at this point, obviously there might have been some question about disclosing the actual contents of the AUSTRAC report to Crown, but you could have at least questioned with them their position in relation to the reinstatement of stronger regulations
I could have.
in respect of junkets, but you didn't, did you?
No.
Did you not raise with GWC or Crown this AUSTRAC report because you thought that it would cause difficulty for Crown and in particular your friends Mr Hume
Absolutely
and Mr
not.
Murray?
Absolutely not.
Because Mr Hume in particular had had the carriage of, on behalf of Crown, for the amendments to the casino manual, hadn't he?
Absolutely not.
And if they were just going to be simply the requirements were going to be reinstated, perhaps that would have reflected adversely on Mr Hume within Crown. Is that what occurred to you?
No, it did not.
We come back to the compliance review, Mr Connolly. Now, the review of junket operations was but one aspect of the compliance review, wasn't it? The compliance review was going to be a whole of GWC review.
That's what was intended.
Yes. And if we go to this document, which is not for publication, the minutes of meeting of GWC of the 22nd of August 2017, GWC.002.0016.0211. At page 0002, item 5.2. This is you providing an update to the GWC members on the compliance review. So it was only at this stage, was it, that a proposed scope and purpose statement for the review was provided to GWC?
I believe so, yes.
Yeah. So this is sort of the starting position, is it, at August 2017?
Yes, it is.
And what you were identifying in the second sentence here was this, wasn't it, that instead of just preparing the compliance review in one whole sum and then handing it over to the GWC members, you were going to provide it in parts on a monthly basis?
Updates on a monthly basis, that's correct, yeah.
Did you prioritise the junket operations part at this point in light of what AUSTRAC had revealed to you?
I don't recall, so I'd suggest no.
Well, the first report was in respect of casino revenue and tax verification procedures, wasn't it?
I believe so.
Well, let's have a look at that. GWC.002.0016.0213, minutes of GWC meeting of the 26th of September 2017, at page 0003. was on the previous page. We might need to go back to 0002. Yes, thank you. You see 5.3 down the bottom?
Yes?
So a report was provided for casino revenue and tax verification procedures at that point.
Yes.
You provided it
Yeah, I believe so,
for
yes.
noting by the GWC.
Yes.
Why did you fasten on that topic first ahead of junket operations?
I don't recall.
If I show you this document, it's not for publication, GWC.0004.0019.0023 is an email to AUSTRAC from you of the 29th of September 2017. Go down to the bottom, please. This is an email that you sent to AUSTRAC subsequent to having flown to Melbourne to participate in a meeting or conference held by AUSTRAC, which a number of the other regulators attended. Is that right?
That's correct.
And on that occasion, you presented an overview of casino regulation in WA,
That's correct.
and there was a discussion about steps that could be taken to better mitigate money laundering risks of junkets at Australian casinos.
That's correct.
And then you wrote this email that commences at the bottom of page 0001.
Mm-hmm.
Can we have a look at the third sentence on this page, or in this email? The Gaming and Wagering Commission does see junkets as an area that requires close monitoring. Why did you say that?
Because the Gaming and Wagering Commission at that time junkets were well and truly on their radar at that time, because of media interest, because of public interest in junket activities at that time.
Well, GWC wasn't doing any monitoring on the
They're
property
not
side.
doing monitoring of property, not at all.
And you had been told fairly and squarely a few months before by AUSTRAC that there were gaps in the Border Force and AUSTRAC monitoring.
Yes.
So when you say the Gaming and Wagering Commission sees junkets as an area that requires close monitoring, what did you have in mind?
I don't recall that at all. Again, probably what I had in mind, and what I had in mind early in the piece and was trying to push, again, was that framework that was actually trying to address it through a consistent framework, so each jurisdiction wasn't doing things on their own, but working together with junket operators.
Well, what did that have to do with close monitoring in Western Australia?
I don't recall what I was getting at there. I don't recall the conversation. I really don't.
And speaking there on behalf of the GWC, had you raised it with the members of the GWC at this point, that
so-
junkets require close monitoring?
I don't recall.
Well, isn't it the case that on the minutes, the last thing that the GWC members had heard about junkets from you was that you had exercised delegated authority to approve removals of
Probably,
requirements
yes.
from the
Yes.
casino manual?
Yes.
And you hadn't raised with them the AUSTRAC reports, the AUSTRAC report?
No.
So in this sentence, after you say GWC does see junkets as an area that requires close monitoring, you go on to say, we are in the process of undertaking a full review of compliance activities, but not in relation to junket operations
No.
at that point.
No.
So why did you say that?
Because we were in the process of undertaking a review of compliance activities at Crown Perth more broadly, and at some point there would be a focus on the regulation of junkets and visit what we were doing in that space.
Well, you say the regulation of junkets and their activity will be a key area of focus.
Yeah.
Do you mean compared to other areas of compliance activity?
Well, yes, and again, what I'm talking about there is having the Gaming and Wagering Commission focus on a framework that worked for everybody and was something that we could achieve something meaningful with.
Well, what were you talking about?
Again, I'm talking about a national framework for.
Yes, but what was this national framework what was the content of it?
So the idea was to have all regulators adopt the same process
and what was the
procedure.
content of that process and procedure?
That
That
was
you were
something
thinking of?
that was something that had to be worked out with regulators. But again, I would be relying on Border Force, AUSTRAC, police. I think for Western Australia, it definitely needed a greater involvement from WA Police. Absolutely,
That was open to you to achieve without a national framework.
it was.
And you had already been told about the deficiencies
I had.
in Border Force and
I had.
AUSTRAC procedures.
Yes.
And when you say, well, I wanted a national framework, had you developed in your own mind a single idea about what that national framework would look like?
At a very, very high level.
So this national framework actually had no content?
Discussions had started with other regulators and then pretty much halted when New South Wales commenced the Bergen inquiry. Yeah.
Well, we're in
No
2017,
Yes,
Mr. Connolly,
yes,
is what
yes,
I'm talking to you
yes,
about, and you're
yes.
telling me that you had the idea
Yes.
of a national framework. It had no content in
No.
2017 in your mind.
No.
So were these just platitudes that you were offering to AUSTRAC at this point?
No, they were intentions to do things, and it didn't happen.
Let's go over the page. You say, I am interested in exploring the idea of an MOU to exchange key information. So you were wanting to provide information to AUSTRAC as well as receive it.
Yes, I was probably more interested in receiving information from AUSTRAC in respect of people.
Well, just in terms of the exchange, what information were you contemplating that GWC could provide to AUSTRAC at this time?
Well, they could provide details of players, or they could provide anything that AUSTRAC might find useful that the GWC could have directed
Well,
the casino licensee to provide.
Sorry. They couldn't provide, GWC couldn't provide the details of players because it had...
We stopped it at that point, yes.
Yes. So what information were you contemplating at this time that GWC could provide?
Well, I think what I was contemplating at that time is AUSTRAC tell us what information they would find useful and we could provide it to them. If that included the names and passport numbers of participants in junkets, that was an easy thing to reinstate.
Now, at September 2017, thereafter, you didn't actually progress this discussion about the MOU with AUSTRAC, did you?
No.
And nor did you identify any alternative measures that GWC could put in place on an interim basis?
No.
Pending completion of the review of junket operations to mitigate the risks of junkets?
No.
Why not?
Well, again, 2017 and 2018 were extremely busy and chaotic periods. And I think I gave evidence in my first appearance here about how much time I was spending on Gaming and Wagering Commission matters. There were other things that on a day-to-day basis were taking priority. And I understand that these are really high risk, highly important matters, but other things were happening that were taking more of my time.
Mr. Connolly, AUSTRAC had told you about a high risk of criminal infiltration and money laundering.
Yes.
And there was media interest around those topics.
Yes.
And your evidence to this commission is other things were more important than addressing that, even on an interim basis.
Well,
is that right?
It was, yes, it is. It is correct, yeah.
So we come back to the compliance review and the monthly updates. We go to the October meeting, gwc.0002.0016.0217. Page 0002. At the top, The next topic chosen to be the subject of a paper is table games integrity. Fairness of the rules, whether they're being played according to the rules, that sort of thing. Why was that prioritised at this point, devoting resources to the preparation of a paper on that topic rather than junket operations?
Honestly, I don't know. I don't recall how and why they were prioritised. Certainly, again, you know, my view, my understanding was that the Gaming and Wagering Commission primarily were responsible for the conduct of gaming operations. So gaming operations presumably got the important focus there.
You were the Deputy Director
Yes, I
General?
was. Yes.
And you were the Chief Casino Officer?
Yes.
And it was absolutely within your remit to say to departmental officers responsible for preparing these papers, the next one you need to do as an urgent priority is junket operations.
That's correct.
And you did not do that.
That's correct.
Why not?
I don't know. I don't know.
November minutes, not for publication, please. GWC.0002.0016.0201. It's the meeting on the 28th of November 2017, page 0002. Need to read it out. 0002. .2. This time we've got a report on security and surveillance. So why was that prioritised?
Again, the same answer.
Well, which is?
I don't know. I don't know why that was prioritised. That was how this was planned, and it was.
And then we go to the December minutes, GWC.0002.0016.0219. Page 0002, item 5.2, electronic gaming machines, integrity of gaming. So this dealt with the integrity of the gaming machines, not any RSG or harm minimisation implications. Is that right?
That's how I understand that, yeah.
Why was that prioritised in December ahead of junkets?
I have no idea.
And you'll note here that the GWC members are starting to complain about the quality of the papers that are being put up to it. Do you see that?
Yes, I do.
And wondering whether this is actually achieving, this compliance review is achieving the desired outcome. What did you do in response to those concerns?
I don't recall exactly what I did in response to that concern in those meetings.
Well, surely you should have gone back to departmental officers and gathered them round and said, well, look, we need to make sure this stays on track.
I'm sure I had conversations with departmental officers. I'm just saying I don't recall the actual detail of those that I can explain to you here.
Well, we go to the February meeting, January presumably being meeting-free month, and that's GWC.0002.0016.0227, 27 February 2018 at page 0002, item 5.2. That was going to be a compliance review about community gaming. So between September and 2017 and February 2018, you had still not prioritised
No, that's
the
correct.
junket operations.
No, that's correct.
Compliance review. It obviously wasn't very important to you, was it?
I didn't. Yes, well, it was important to me, but obviously that's a failing on my part. I have.
And we see that the agenda item was actually withdrawn.
Yes.
And the compliance review was effectively ceased at that point, wasn't it?
I don't recall it going any further forward at that point.
So it was ceased.
Yeah.
And no compliance review of junkets was ever undertaken, as I
It
think
hasn't
you
been
mentioned.
undertaken at this point, no.
Despite having told AUSTRAC previously that it was an area that required close monitoring.
Yes.
And having the year before removed the residual regulations for approval of junket operators and providing information in
Yes.
relation to junket participants to the GWC. Is the reason that you never proceeded with a compliance review, at least in relation to junket operations, because you thought it obvious that if a review was conducted, it would lead to stricter regulation of junkets to Crown Perth,
No,
including the reinstatement of requirements for approval of junket operators?
no. I have no problem with the reinstatement of those requirements. I have no problem with any of the requirements that would come out of any compliance review.
Were you concerned that increased junket regulation in respect of junkets to Crown Perth might pose difficulties for Crown in attracting junkets to Perth Casino?
No, it's not
That
a
it might-
concern of mine.
Or that it might pose difficulties for Mr Hume, your friend, having been involved in having the approval and information requirements in the casino and the risk of
Absolutely not. Absolutely not.
Now, I want to change topics and talk to you about EGMs
Yep.
and responsible service of game,
Mhm.
RSG for short. In relation to electronic gaming machines, or EGMs, you were aware, at least from 2012, when you commenced as CCO, weren't you, that EGMs are of a particular concern in terms of the risk of harm arising from their regular use?
Like most forms of gambling, yes.
But EGMs in particular?
In particular, the ease of access and ease of use probably makes them so, yeah. I would agree with that, yes.
And you were aware from 2012 of the prohibition in Western Australia of poker machines?
Yes.
And did you understand that the reason for the prohibition was because of the risk of harm arising from the regular use of poker machines?
I didn't really understand the reason for the prohibition. I understood the prohibition. I didn't really understand the reason for that.
At all?
I understood that to be in the Gaming and Wagering Commission Act, to restrict their proliferation throughout the community. So I guess as a harm minimisation measure, yes.
Well, you understood the reason for the prohibition was because of the risk of harm
Yeah.
arising from the regular use of poker machines.
Yes.
And you're aware subsequently of the WA appendix to the Gaming Machine National Standard that
Yes.
was introduced in 2016,
Yes.
which set out the factors to be used to ensure that games are not played on poker machines in Western Australia.
Can I just take you back? 2016, what
It's
was?
the national standard.
It's the current standard?
Yes.
So it wasn't, there's been a national standards for,
Yeah.
Yeah.
2016 is the most recent.
is the most recent, I believe,
And
yes.
WA has an appendix to that standard.
That's correct.
And that sets out the factors in that appendix
That's correct.
that one follows to ensure that games are not played on poker machines in Western Australia.
That's correct. Because there is no definitive definition of a poker machine.
So the GWC itself sets out the factors and in effect via that appendix, on your understanding, what constitutes a poker machine and what doesn't.
That's how I understand it, yeah.
And then if we look at the standard as at the 1st of October 2016, this is GWC.003.001.009.
07.
I've misread it. GWC.003.007.009. The operator was ahead of me. But I've amended that for the transcript. So this is the standard as at 1 October 2016, and I want to be clear, it's been amended since then, and I'll ask you some questions about the amendments at a later point in time, but I want to talk to you about it as it stood at October 2016 right now. And if we go to page 0005, it's weird. Yes, 0005. At WA 4.2, there's the beginnings of a table to determine what a poker machine is. And if we display the following page side by side with this one, so we can see the table in its full format. As at October 2016, when this appendix was in force, Did you understand that many, if not all of the factors nominated here, 1 through 10, had the objective of harm minimisation?
In some way, shape or form, yes.
For example, type of symbols that could be used.
Yes.
Or could not be used.
Could not be
more
used, yeah.
Speed of play.
Yes.
Whether or not the symbols were on a fixed reel strip. And you understood, didn't you, that to a greater or lesser extent these features, either directly or indirectly, were considered to contribute to the addictive characteristics of a poker machine?
Yes, I think that's, yeah.
Now, you're also aware of an EGM policy that the GWC had, and again directed towards differentiating between a poker machine and an EGM. Yes?
Yes.
And by the time you commenced as CCO in 2012, that EGM policy was the 2011 version. Is that right?
I don't recall, but
Well, let's just
yes,
be
yeah.
clear about that. If we go to this document, which is not for publication, GWC.000.016.0035_R. These are the agenda papers for the GWC meeting of 27 September 2011 at page 0407. Page 0407. And here we have an agenda paper, brief in nature, with a recommendation for the GWC to approve the EGM policy. And it mentions in the text, in the second paragraph, that the policy that's attached here, that I'll take you to in a moment, is based on the Commission's paper of December 2005, which specifies requirements for determining a machine not to be a poker machine. And then you've got the policy at attachment 3. So taking that in order, 0408 is the start of the 2005 policy, 2005 paper for differentiating between EGMs and poker machines. And that forms the basis for the policy that appears at 0417. You recognise that?
Yes.
Yeah. And again, this is the version as at
Yes.
2011.
Yes.
So it gets amended. And it contains similar information to the appendix, doesn't it?
It does,
The
yeah.
policy. Except if we go to page 0418, it has at numbered paragraph 4 this discussion about winning combinations and the prohibition at subparagraph 3 on multi-line, multi-directional winning combinations. That's not actually in the appendix, but features here in the policy and not permitted as at 2011. Yes? You agree with all of that?
I do.
And you understood that the prohibition on multi-line and multi-directional winning combinations was again because of the harmful characteristic that had in a poker machine, causing people to bet more because there were more ways in which you could have a winning combination.
I'm not really sure on the justification for point 3 there, the multi-line. But presumably that's correct. But I don't know. I don't know if I had any involvement in how that was determined.
So if we go back, but you understood that it had primarily at its heart some kind of harm minimisation objective.
Or some kind of objective to stop machines looking like spinning wheel poker machines. Yeah.
But again, for harm minimisation purposes or objectives.
I wasn't involved in the initial, but
No,
I
I'm
would
asking
presume
what you
so.
assumed.
Oh, I would assume so, yes.
Now, if we go back to page 0413, when we're in the 2005 paper that the 2011 policy is based on, you see that table there,
I do.
which is a sort of a ready reckoner, if you like, of the differences between video poker machines and video gaming machines at that time in 2005.
Yep.
And you used that table, didn't you, from time to time as a ready reckoner of how to distinguish between a poker machine and a EGM?
I don't recall using it, but I could have done. I certainly could have, yep.
You used it, didn't you? You copied and pasted it into a briefing note you prepared for Duncan Ord in July 2017.
Yes.
Recall doing that?
Yep.
Now, do you recall that in March 2014 you were asked by GWC to examine the speed of play requirement in the appendix to the national standard?
Yes.
If we have a look at these minutes of meeting of 25 March 2014, DLG.0002.002.0052 at page 0007, item 5.2. So the GWC at this point was looking at a particular EGM and the ball delivery mechanism in that EGM.
Yep.
And in the second paragraph, well, I'll just go back. The first paragraph is looking at how this EGM is using a video depiction of rotating balls dropping into tubes. And the members go on to say in the second paragraph they accept that the machines using a ball delivery system that are not poker machines, etc. But then it says the Deputy Director General, that's you, was requested to liaise with Crown Perth with a view to decreasing the game speed by 20%.
Yep.
You understood the game speed at that time was a 5-second minimum?
5-second minimum, that's correct.
And again, for harm minimisation reasons.
Yes.
And
now, I was asked to do that on the basis of the video that was provided to the Commission.
in relation to that game?
In relation to that game, and I think what members, not all members, understood was that was not actually a depiction of the game being played. It was a video representation of what the game was going to be, and the speed was faster than it would have been under.
Yes, but what you were asked to do was
correct.
to liaise with Crown Perth
Yes.
with a view to decreasing the game speed by a further 20%.
Yes.
So you understood precisely what GWC was asking you to do.
Yes, I did.
Go to Crown and discuss with them
Yes.
with the view to getting the outcome GWC wanted, which was a decrease of the game speed by a further 20%,
Yes.
which you meant increasing it from 5 seconds to 6 seconds.
Yes. I also understood it as part of that instruction that they wanted to understand the implications of that as well, even though that is not captured.
Well, you were told precisely what you wanted to do, what you were wanting.
Yes.
They were wanting you to do,
Yes.
and it's recorded in the minutes.
Yes, it is.
Go to Crown, liaise with them, with a view to decreasing the game speed from 5 seconds to 6
Yes.
seconds. And you appreciated that to slow the speed of play, your assumption was it would be to Crown's financial disadvantage, didn't you?
Yes.
In the sense that the slower the speed of play, the fewer the games that are played
That's
in
correct.
a finite period, the fewer bets that are placed. Yes?
Yes.
Now, a few days later, on the 27th of March 2014, there's an Operations Division meeting. This time you're an apology for this meeting, but you would have been provided with the minutes subsequently. Is that
Yes.
right? DLG.0004.001.0236. Item 4.1 at page 002, second paragraph. Says DDG further advised, presumably that's, let me just check that you are absentee, having said that you were. Let's go up to page 1. I'm sorry,
No, I'm there.
I've misunderstood. So
Yeah.
you were there.
Yeah.
So let's go to page 0002. You advised GWC had been examining the game. You further advised, this is the second paragraph, GWC required the department to examine the current 5-second speed of play provisions detailed in the appendix and provide a report on whether this speed of play should be increased to 6 seconds. Well, that's not what the minutes had told you to do.
It's not what's in the minutes, but I believe that's 20% increase, is it not? 5 seconds. So it talks about increasing the speed by 20% or decreasing the speed by 20%, is that not?
GWC members told you to have to liaise with Crown with a view to decreasing the speed from 5 to 6 seconds for that game. You recall that?
Yes.
And here you say something different. GWC required the department to examine the 5-second speed of play provision in the appendix and provide a report on whether the speed of play should be increased to 6 seconds. Where did you get that idea from?
That was my understanding of the instruction from the GWC, whether that's captured completely in the minutes or not. But it was to explore the idea and the implications of decreasing the speed of machines by 20% and what that meant.
Now, over the page at 0003, you advised that you would liaise with Crown Perth in that regard.
Yes.
And then you engaged with both Mr. Preston and Mr. Hume about that, didn't you?
Yes, I did.
At the same time, you were emailing Mr. Preston and Mr. Murray about boats and fishing. You'd agree?
Yes, probably yes.
Well, probably. Let's have
Yes,
a look.
yes, I agree.
CRW.709.132.2387, an email of the 31st of March 2014.
Yes, I agree.
And an email of the 7th of April 2014, CRW.709.132.1739. Emailing Mr. Preston, Mr. Murray, Mr. Hume about boats and fishing.
Yes, I agree.
Did it occur to you that it might not be appropriate to be engaging with officers of Crown Perth in this way while you were actively engaged in discussing with them a proposal from the GWC to increase the speed of play?
Obviously, it didn't occur to me at the time, but with the benefit of hindsight and reflection, yes, it does. I would not have done that had I thought about it as I should have.
Did you subsequently meet with Mr. Hume in around June 2014 and ask him if Crown Perth could provide you with high-level dot points explaining the impact of the change on Crown Perth, of the increase in the speed of play, so that you could present it as your views to the GWC at its meeting on 24 June 2014?
I know, I'm not presenting them as my views, as understanding the implications of that and then presenting that in my paper as part of my views. So I wanted to get an understanding of what they were estimating what would mean to them.
CRW.709.139.8384. Now, this isn't an email in which you're involved. You've neither written it nor received it. It's from Mr. Hume to Mr. Bossy, Mr. Preston. Hi, Lonnie and Josh. You may recall some months ago GWC requested senior officers at the department to examine the speed of play requirement detailed in the appendix, whether this should be increased by 20%, that is to 6 seconds. Mr. Mick Connolly has just met with me and requested if we could provide him with a high level and in a dot point form document explaining the impact this change will have on Crown Perth. Mick has requested us to provide with this information to him by 20 June, as he intends to present his views to the GWC at that meeting on the 24th.
So that information was to inform my views, not to be my view.
Did you wish to advocate for Crown in respect of this change?
I didn't see, my personal view, I didn't see a need to change from the requirement as it had been for a long period of time.
Why did that matter? That you
It
didn't
didn't.
see a need to change?
It didn't matter. But I'm not advocating for Crown. I'm putting my views.
Had
And
you-
my view would be that I didn't see a need for that.
Had you decided already that you did not wish to see if Crown could be persuaded to accept an increase of the minimum speed to 6 seconds?
I think as part of those conversations we'd already had, captured in the minutes or not, they'd already informed me that they wouldn't voluntarily do that. That wouldn't be something that they would offer up voluntarily, so it would be something that would have to be imposed.
Did you see it as your role to advocate for the GWC members for the to Crown for the increase of the minimum speed of play to 6 seconds?
I saw it as my role to inform Crown that that's what the Gaming Commission was considering, and that the and my role to inform the Wagering Commission on what the full implications of that decision may be, because there may be unwanted implications for that they weren't considering, rather than, and again, they were looking at a video, not an actual game.
Did you consider it your role to try to ascertain whether there were benefits to increasing the minimum speed of play?
I think there are obvious benefits to increasing the minimum speed of play, and their harm minimisation benefits. What they do is reduce the number of spins that can happen in any period of time. And I think the Commission members understood that, which is why they asked for that. So I thought that was obvious. Now, again, the Commission would need to weigh and balance those obvious advantages against the implications of that decision, what that meant for Crown as an employer, what that meant for revenue and tax, and for all the other things that go along with that.
We go to DLG.8001.0022.7525. This is an email exchange between you and Mr. Preston of the 20th of June 2014. And if we go to the bottom of the email, on this page at 7525, you've got Mr. Preston writing to you and saying, is the info suffice? Presumably he means sufficient. And if we go over the page, you can see there that he has given you a set of dot points as you asked for to explicate Crown's position as to the implications of increasing the minimum speed of play to 6 seconds. He mentions nothing about harm minimisation, does
No, he
he?
doesn't.
And where he says at page 7525 at the bottom, will this information suffice, you understood him to mean, would it suffice to dissuade the GWC from increasing the minimum speed of play?
No, I understood him to be responding to the questions that I'd asked him about those implications. I wanted to know what the financial implications of that were likely to be. And as I said to him there, it sounds a little dramatic to me. I think they were overestimated. But that's what I got from him.
So what you say in response to Mr. Preston, if we come to about point 3 on page 7525, yeah, I have already put together dot points for an argument against increasing the speed,
Yes.
which includes some of the info you provided. Why did you think it was your role to advance arguments against the increase of the speed of play?
Well, again, I probably haven't chosen my words particularly well, and the last sentence will demonstrate that even further, the second last sentence. But I'm mounting an argument both ways. So I have an argument for and against that. The argument for it is clearly a harm minimisation strategy. The argument against it is the financial impact it has on Crown and on that business. So I didn't just see it as my role to argue against. My role is to provide information and try to balance that.
Well, you don't speak of balance here, do you, in
No,
this
I don't.
email?
No, I don't, and it's poorly worded.
Right. So you say, so let me go back. You'd put together dot points for an argument against increasing the speed before you had heard from Crown as to its position, its justification.
Yeah.
Yes?
Mhm.
And then in the next sentence, the revenue loss figures, these are the ones Mr Preston has provided you, sound a bit heavy, by which you meant overstated.
Yes.
And then you say, regardless, I don't think it's a good idea and the figures will be useful for me for illustration. Why did you not think it was a good idea to increase the minimum speed of play?
Again, 5 seconds has been long-standing and has proved to be a useful measure. The other part of that is if all of those machines are changed, if the requirement changes to 5 seconds blanket, there is a considerable amount of administrative process and work that goes around that, and I just didn't know if we had the capacity to do that. But
What on earth are you talking about,
well,
Mr Conley?
5 seconds to me is a reasonable number. It is stood the test of time.
Let me just come back to your administrative arrangements
Yeah.
around the 6 seconds. What are
Yeah.
you talking about?
All those games software would have to be changed to have a 6 second minimum spin speed.
As they would if you were going the other way and decreasing the minimum speed.
That's correct.
From 5 seconds to 3 seconds.
That's
for
correct.
example.
But they wouldn't all go that way as a blanket. They would be progressively.
Well,
Yeah.
presumably you could negotiate that as part of a change, couldn't you?
Yeah.
So a one-off alteration of machines, recalibration of them to change the minimum speed of play.
Yeah.
That are you saying that was one reason you were against it?
I was personally, I thought 5 seconds was an appropriate spin time. It is the slowest spin time in Australia. It remains the slowest spin time in Australia.
What was the basis for your conviction that it was an appropriate spin time?
It stood the test of time. It's been there for that period, that length of time. And again, the request for that came out of members looking at a video of a game, not an actual game. So I thought that in itself was a flawed rationale for going, let's increase the game speed by 20%.
So GWC had either asked you to liaise to get that 6 seconds for one particular game,
Yep.
or asked you to prepare a report on the pros and cons of increasing the speed across the board. And you decided not to interrogate the pro case on the basis that 5 seconds had stood the test of time, so why change it?
Well, I think the pro case is obvious. The pro case is reducing the amount of spins per hour. What else is there in the pro case? It is definitely a harm minimisation measure. It would have a harm minimisation impact because it reduces the number of spins. It reduces the ability. People have to stay there longer to spend the same amount of money. The other side of the argument was, is it worth that? It was for the Commission to weigh and balance that as a decision.
Well, no, you'd effectively decided you weren't going to allow it to weigh that evenly, Mr. Connolly, because you were coming out with arguments against it. You said it was a bad idea.
I think the idea was flawed. The basis of the idea was flawed because it was considered on the video. That's where I think was where their mistake was. They looked at a video and went, "This game's too fast," and the knee-jerk decision to that was, "We need to decrease the speed by 20%."
Didn't you just tell me it had obvious harm minimisation benefits?
It does.
So that's not a flawed idea.
No, but where the genesis of that was watching that video and going, "This game's too fast." And that's not what was, if they'd seen the correct timing on that video, I don't know whether they would have said we need to reduce this across the board.
Just following your logic there, if absent that game, the GWC had just said to you in meeting, we'd like you to explore whether games should be, the minimum game speed should generally be increased to 6 seconds.
Yep.
You would have thought that that was a more solid foundation.
It would have
to
made more
pursue that
sense to
idea.
me, I think, yeah.
But because they had watched a video in relation to one particular game, and that had led them to make the inquiry of you,
Yep.
it was a bad idea.
Effectively, yes.
Well, that makes no sense.
No,
does it?
sorry, but that's how I saw
Well,
it.
that makes no sense, does it?
That's how I saw it.
It makes no sense.
Okay.
Well, I think he's answered the question, Ms. Cahill.
Now, coming back to the overstatement of the revenue loss figures, you say the figures will be useful for you for illustration. So overstated figures, which you understood to be not accurate, you were nevertheless prepared to use to demonstrate to the GWC that they shouldn't increase the minimum speed of play to 6 seconds.
I think that when I went to the GWC to show that, I said to the GWC that these are the figures provided by Crown and they may have been overstated. They sound heavy to me.
You say you said that to
I
the
think I
GWC.
did. Yes, I believe I did. I wouldn't have hid that from the Gaming Wagering Commission if that's what I thought.
Next paragraph, we talk about the thin end of the wedge when considering your proposals. What you're referring to there is when Crown goes too far in asking for
Yep.
approvals and dispensations and the like. And it's just as valid a concern when considering ours. You considered an increase in the minimum speed of play to 6 seconds to be the thin end of the wedge as far as...
Oh, I don't know if that's what I meant.
Well, it's what you said.
It might be what I said, but I don't think that's what I meant. As I don't know what
Well-
that's intended to mean. I read it the same as you, but I don't think that's what I was talking about at that
Isn't
time.
it the case that you regarded the GWC members' proposal to reduce the minimum speed, to increase the minimum speed of games to 6 seconds as the thin end of the wedge?
No, I see the casino licensees' requests more often as the thin end of the wedge. I don't see that the Commission has a thin end of the wedge. The Commission has the ability to do whatever they think is appropriate.
This sounds a little dramatic, but the current system and requirements work. What do you mean by that?
Again, what I was talking about before, I think the system as it was then worked effectively to balance harm minimisation against the commercial interests of the casino licensee.
How would you know?
A relatively low incidence of problem gambling when compared to all the other states, which WA does have, and those controls that have been in place for such a long period of time that keep that position. WA's maintained that position throughout prevalence studies over a long period of time.
Well, WA doesn't have EGMs outside of the casino,
No, it
except
doesn't.
in very specific and limited circumstances, which is essentially the reason why the prevalence of addictive gambling behaviours is lower in WA than other states. You understand that very well, don't you?
I understand that, yes.
But in terms of the relative benefit of a 5 second minimum speed of play versus 6 seconds, in terms of harm minimisation, you wouldn't know, would you?
No, there would have to be a prevalence study after that to see what impact that had on problem gambling.
Might actually be a great idea.
It might be a great idea.
Moving from 5 seconds to 6 seconds might materially reduce the incidence of harm
It may.
minimisation. It might really be worth it.
It might keep people at a casino for longer periods of time, spending more money than they would otherwise. Who knows?
Who knows?
Who knows?
And you didn't know when you wrote this email.
No.
No. And after you wrote this email, you didn't undertake any investigations or research to find out did you?
Well, investigations or research to find out are going to take time. The Commission wanted a report. They would have to change those features and see what impact they had in order to find out what difference that had made.
Now, penultimate paragraph, which I think you've already
Yeah.
referred to, you obviously have read that overnight and reflected on that,
I've
have you?
reflected on that.
Yeah.
It is very poor judgment.
Anyway, I can put my hand on my heart and say we have consulted.
Yeah.
You hadn't consulted with Crown to advocate for an increase in the minimum speed of play to 6 seconds, had you?
I think at the operations meeting, I consulted with Crown and said, asked the questions of them, what they think about that. What are the implications? Are you prepared to accept that? Will you give that a trial? Now, they're not captured in the minutes, but those conversations were had.
Well, you had asked Crown to provide you with supporting information to argue against the proposal.
I did.
And ultimately, you recommended to the GWC that it not increase the minimum speed of play.
I did.
Let's go to the minutes of meeting of the 24th of June 2014, DLG.0002002.0052. At page 0019. And if we go to, yes, down the bottom. Why didn't you make this an agenda paper item?
I really don't know. It was a matter arising, so it was reported as a matter arising.
So you reported on your inquiries relating to reducing the speed of play, outlined a number of adverse consequences, and that included that primarily that Crown was going to lose a significant amount of revenue.
Well, by their estimates, now I would have said to the Commission that they're their estimates and you have to take that with a grain of salt.
Well, what were the adverse consequences that you identified?
I'm talking about revenue for Crown.
Yeah. Any others?
Not that I can recall.
So there was one adverse consequence,
Yeah.
which is that Crown would lose revenue.
Yeah.
Versus what you said was the obvious harm minimisation benefits of increasing the minimum speed of play.
And I would have said that to the Commission as well. I mean, that's a summary of a discussion and just a grab from the end. But I would have said that to them. And again, I've pointed out to the Commission that that's consideration for their decision. It's not my decision. They need to make a decision on whether or not they want to trial that.
Let's go over the page. In order to reduce inconsistencies in the requirements between game types. So it was only in relation to the game that had been...
I think so, yes. The ball dropping, I think that was the first iteration of that type of game.
So you didn't understand that GWC was asking you to liaise about an across-the-board increase in the minimum game speed?
I got the information for across the board as well.
But you understood that that's not what they were asking you, because you've identified here that one of your arguments against the increase was that it would create inconsistencies between different games.
Yeah, look, my recollection of all this is obviously a little vague and a little hazy. It's 2014, but yeah.
I just note, Commissioners, that there's a patron name on that page, and it may be appropriate not to reveal that publicly.
Thank you. Thank you, Mr. Damananda.
And would this be an appropriate time?
I just need one question to finish off on that topic, Commissioner, if I may. Isn't it the case, Mr. Connolly, that in relation to the GWC's limited request to liaise with Crown Casino with a view to increasing the minimum speed of play for this one particular game, you from the outset worked hard to ensure that that increase in minimum speed of play did not occur?
No, I don't accept that. I don't believe that that minimum increase should. I think the position was solid as it was, but I did not work hard against that. And they're decisions for the Commission, not for me.
Thank you.
Mr Conley, we will now take lunch until 2 p.m, so you're free to go, and we will adjourn till 2 p.m.
Thank you.
All rise.